this is an accepted definition, usually used by infectious doctors, medical journals, et cetera, of what they consider accepted scientific information. I think he said in his testimony today, Dr. Senator Stephan, about the fact that we want to make sure that who's ever making these decisions, whether that be school boards or city councils, et cetera, that they make it on sound scientific means.
Well, Madam Chair and Senator Gossage, just reading it, of course, at first blush, this particular definition says, quote, in section E, I guess it's about the data shall not include observational studies, expert opinion, anecdotal experience, or statistically insignificant studies. Methods of control shall also consider the impact upon the economy and mental health, unquote. I would be a little more comfortable seeing where accepted scientific or from what source such a definition would exclude observational studies, expert opinions, or anecdotal experiences, and where these methods of control would consider, I mean, again, scientific data would look at the impact of the economy and mental health. I'd like to see, again, where these definitions are drawn from, because at least to my limited knowledge, and I'm not a scientist nor a doctor, but these are some of the areas that I look to when I'm looking at science.
Go ahead, Senator Gossage.
Thank you, Madam Chair, for your patience. And again, I didn't write this, but I do know in the field of health insurance, I'm back in my background, and I do have a daughter-in-law as a surgical oncologist at Mayo Clinic. And then the doctors that I work with across the country, they don't look at someone's opinion or anecdotal experience. And he used the example of this one person wore a mask and it didn't help, you know, or this one person wore a mask and this. It should be based on scientific study where they have done statistical evidence based on a certain number. For example, we tested these 100 students in a trial and discovered this or that, as opposed to, we're just going to make a decision, we're going to call it scientific. If somebody just tells us something or somebody observed something, it needs to actually be scientific data.
Senator
Chair.
Haley.
Thank you, Madam Chair, and thank you, Senator Gossage. Maybe I need to ask Mr. Thompson, and I think this was asked of him earlier, I apologize if I'm repeating, but for our revisor, this may even be beyond his purview because we don't often get into that. Is this definition that is in the amendment, if Jason Thompson is available, is a similar, or is there any other definition of accepted scientific or scientific that's currently in the statute? And is this in sync, this language in sync, or is it divergent from what we've seen before? I don't know if I could make that question clearer, Madam Chair. If he needs me to repeat it, I will.
Mr. Thompson, if you can answer.
Thank you, Madam Chair. This is Jason Thompson. First question, anything in our statutes currently? No. So the answer to the second question, divergent from? No.
So,
thank you.
So just to affirm, we're not defining in any of his known interpretations of the statute. And full disclosure, I believe that Jason Thompson is a walking statute book. So, I mean, he doesn't have to Google it. He knows it, okay? So to his knowledge, which is extensive, we don't have a definition of accepted scientific already in our statutes right now, Madam Chair.
Thank you, Senator Haley. I think that was the response of Mr. Thompson, and just so I'm correct in understanding what the reply was, is it correct, Mr. Thompson, that currently in statute we don't have a definition of accepted scientific means. Is that right?
Thank you, Madam Chair. This is Jason Thompson, and I appreciate the flattery, but I'm aware of this one because we had to look recently to make sure that there wasn't a definition. And the term accepted scientific means or accepted scientific data or accepted scientific practice appears in this bill and in Chapter 65, but it's never defined. It apparently has some sort of meaning within the health community. And so this is an attempt to define it based on the request that was given to us.
One last question, if you'll indulge me, please, Madam Chair. And I don't know if this would be, well, it wouldn't be of the reviser who was good enough to draft it, but I guess to Senator Gossage, how do methods of control, quote, methods of control shall also consider the impact upon the economy and mental health, unquote. How is that not a separate consideration from what science, or where is there in science, and you have an extensive history and family members that are involved, how is that scientific, or what sort of economic science, or I'm having trouble with, obviously, pulling this into a definition of accepted science. And could you please help me to better understand why that would be in a definition of science, Madam Chair?
Thank you. Senator Gossage?
I will share with you, Senator Haley, that I had reservations about that very same line at the end, because I agree that I think it's two separate things. One is the science, and then the other is, that's fine, thank you for the science, but then how will that affect the economy, et cetera? And I would be fine with striking that line, and I believe that the carrier, which I guess is I, of the amendment, but, you know, Dr. Steffen and I, in discussion of that, I shared that same reservation. So I wanted to bring it to the committee as he had drafted it, but I think that he would be fine with striking it.
So, Madam Chair, so thank you. So is this language then, Senator Gossage, this then was the language that Senator Steffen referenced during his testimony, and that it was drawn directly from his recommendations for what it would be?
Yeah, that's correct, Senator. Yes, if we could, I think we had a question next from Senator Thompson. Did you have a question? Yes, and then Senator Corson, and then Senator Pyle.
Yeah, and this is more of a comment than a question, but I understand what the amendment is attempting to do, which you look at all the different executive orders that were made, probably on the recommendation of the health director, in his opinion, who is probably following the opinion of the CDC, who have changed their opinion numerous times on masking, social distancing. Prior to the pandemic, they actually said masks would not work. They also said social distancing should only be to 3 feet apart. And so I would consider those expert opinions, which changed, as opposed to scientific studies. And I believe what is attempting to be accomplished with this amendment is to open up the possibility of consideration of a number of different scientific studies that I know I was aware of that said that masks do not work, that says social distancing does not work, that says that herd immunity is a fact of life. And none of that was ever considered. The CDC was rubber stamped by the state health director, by the county directors. I believe what this attempt is to do in defining the accepted scientific means is to open it up to consideration of additional studies which are accepted by the scientific community. And the methods of control shall also consider the impact upon the economy and the health. I don't think you can have a good health without a good economy. And I think we're seeing that. The access to medical care was not there. And, you know, we had a very myopic view of how to handle this pandemic from the get-go. And I believe that this opens it up to at least questioning those health directors or those county commissioners or anybody else who's making this, and they can't just rely on the CDC to make those decisions for us. And because we saw some areas in western Kansas where they were closed down for months when there was no spread out there. So I think this is his attempt and the carrier's attempt to at least open that up for consideration. And I would be in support of this amendment.
Senator Gossage, and then Senator Corson and Senator Pyle. Go ahead.
And you know, perhaps it'd be more comfortable if we were to change methods of control may also consider the impact upon the economy and mental health.
Thank you. Senator Corson.
Thank you, Madam Chair. I'm concerned about this amendment, although I understand the senator's concern, and I believe what she was trying to get at. But I just want to again remind us that we are talking about emergencies. We are talking about, this is a statute dealing with how we respond to very fast, very quick, fast moving emergencies. And my worry is when I look at this is that, you know, that we may not have things that are acknowledged as effective by high quality scientific data that have been subject to systematic reviews of completed high quality randomized controlled trials. Those things can take months or even in many cases years before we would have those. I mean, imagine a deadly new virus. Forget about COVID for a second, but think about that's moving very quickly through our population. It could just be months or years before we, I believe, would have the sort of information that this amendment is requiring us to have. And the reality of the world is that we may have to rely on trained folks providing expert opinion, and the best that we can change, as we've seen throughout this pandemic. I believe Senator Thompson spoke quite eloquently to how it has changed based on new information, but I think to set the bar at having these really refined quality scientific studies is going to leave us paralyzed. And again, we're responding to an emergency, and I don't think we want to have our hands tied and be just paralyzed. So thank you, Madam Chair.
Thank you, Senator Corson. Senator Pyle.
Thank you, Madam Chair. I just was curious as to the senator from Wyandott's comments. Would he be more comfortable if we divided the question at each period and divided it into 3 pieces? The first piece would end at the period following the word trials. Second piece would be after the period of the word studies. And then the third piece, I mean, I don't know. I don't know what the committee wants to do. I'm just trying to suggest. I know there's people uncomfortable with the third part, second part. So maybe the first part's what we get. I don't know. I'm just asking. And if he isn't, he could make that motion. Thank you.
Senator Thompson, did you have a comment, or I'm sorry?
Oh, I was just kind of responding to Senator Corson's comments, and I appreciate that you know he's looking at. My suggestion would be that this is a very unique situation that we're attempting to respond to, and there's never been a statewide disaster this long. There's only been one other statewide disaster. That was an ice storm, and it only lasted, I think, a week. So this has presented us with the problems of you know, that we never foresaw, and I think that's what this is attempting to do. Thank you, Madam Chair.
Thank you. Senator Wilborn, did you have a comment or a question?
Thank you, Madam Chairman, and I do. I sense, first of all, I commend Senator Stephan. I understand where he's headed with this. I sense a certain uneasiness with the way this is worded. And I don't want to parrot Senator Corson's remarks, but you know, there is a difference between a short-term emergency, and it takes a long time for a scientific study to develop that is credible scientifically. One thing to have the study when you react to a pandemic over time, then you can point to the data that has been developed possibly overseas, all over the world. There'll be a number of studies come in that you can rely on. But when you have to make a decision within 24 hours, there's no scientific study. And there's not going to be for a while. So I respect Senator Stephan. He's a scientist, a doctor. I get all that. But I think we do have an element, like in the mathematics, called the time element in calculus. I think the time element here impacts whether you can rely upon a scientific study versus having to do what you need to do right now based upon expert advice. Thank you.
Senator Haley.
Well, thank you, and I thank Senator Pyle for it. I had not considered the division of the question, and indeed, I do think if as read, the first sentence, I think is a good definition for what is a quote-unquote accepted scientific. It's the remaining two sentences that I would have some concern about, that begin with data, and then the other one begins with methods. Those are the ones I think that go outside the realm, far outside the realm of consideration. So as to the division of the question, I think you have two different considerations there. One solid, and, well, in my opinion, the other not so.
Before we move on, is division of the question, is that in order, Mr. Revisor, or is that something that needs to be brought in writing to the committee?
Thank you, Madam Chair. This is Jason Thompson again with the revisor. I'm aware that on the floor you would usually make a note of parts A, B, or C, or however you wanted to do it. But in this case, you're in committee. It's subject to the chair. If you have a copy and you wanted to mark it, as long as those of us following along procedurally, it could be okay. Just make sure you're being clear to everyone following along what they're voting on.
Absolutely. Thank you, Mr. Revisor. Senator Gossage.
I just want to point out that I work regularly. Every 2 weeks, I'm on a large conference call with about 300 doctors across the country and other countries, including India. And these countries have been dealing with coronaviruses for years. This is not the first one. COVID-19 was just named that because it was in the year 2019 when they first encountered it. So there have been lots of studies that have been done about other corona-type viruses and how they handled those and what they had used. Yes, this one was different, but not as different as a lot of people think. So there are far more studies out there of what has already been done. So a lot of times you want to look at, well, is this similar to what has happened before and what could be done? So I am open to, changing the question, whatever. The main concern that I personally have is defining it. We don't have a definition anywhere. We want to define it. And ending with the word trials, I think, is a good definition that we saw. And as you said, the first sentence, Senator Haley. And so I think anything after that we can discuss, but I think that that's a really good definition.
Thank you, Senator Gossage. Committee, I've been listening to the debate and points well taken on both sides. I understand the intent of the good senator from Reno County. He's from Reno County, right? Yeah, from Reno County, in proposing this to committee. I share some of the concerns that were stated in committee here. Would entertain a motion along the lines of, what Senator Gossage had suggested, but I think we have a lot of other work to do on this bill, and like I said, I would entertain a motion or several motions on the amendment, if we have any. Yes, Senator Gossage.
Forgive my being new that I don't realize what, how the process. So I'll say what I'm thinking, and then you can share with me if that's inappropriate. But I would be fine with striking the rest of this and just leaving the definition, which I think was the original purpose. ending with the word trials, period, and let the balloon in there.
Committee, the motion that I'm looking for a second on would be the balloon amendment would end at the word trials and strike the remaining 2 sentences of the balloon. And we have a second from Senator Thompson. Is there discussion on the motion? I have a few comments. Again, the purpose of the bill is to be governing the health and public welfare of the state or parts of it during an emergency, and I'm not sure how applicable the definition is when we're responding to an emergency. So I would ask the committee to consider that. Yes, Senator Baumgartner.
Thank you, Madam Chair. You know, one of the things that really we haven't circled back to, we keep focusing on COVID. And we focus on just how it impacted us in Kansas with regard to COVID. But I will hearken back to, can't believe I'm doing this, but one of the things that was mentioned by our secretary. And what we're talking about, you know, if we had a problem with our power plant, that would be radiation, severe radiation. There's all kinds of scientific research. Most emergencies, there is a protocol for. You implement them immediately. Now, I know the secretary talked about one particular cruise and how the state of Kansas handled those Kansans that were on that cruise. But the fact of the matter is, one of the first cruise liners that had exposure to COVID, those folks were flown to, I believe, Omaha, Nebraska. And they already had their contagious protocol for what to do with something. They already had that in place. They already had the filtration system. That's why they were flown there. So though it may not have been in Kansas, whatever that emergency, that health emergency might be, for the most part, it's happened somewhere else in the world, and we would be able to call upon accepted scientific means. But here's the deal. Everyone's focusing on it just happened. We just had an explosion. We just had a meltdown. We just had whatever. But if we do use our 2020 vision, which is what happened in the past, and we just look since March, what this really is mandating is that as ongoing recommendations are made, it is going to be based on methods of controlled ways in which to deal with that particular infection or that particular communicable disease. And so this initial definition, it fits right into what we talk about, the ongoing. Same thing was true with SARS. It fits into what we want if we're going to change recommendations. Thank you, Madam Chair.
Thank you, Senator Baumgartner. Let me ask the reviser a question to get back to some earlier questions in our discussion regarding the term accepted scientific means. What we're doing when we are setting this up in this bill, Senate Bill 273, is we are setting up the requirements so that then you can have review of the order. Was it based on accepted scientific means or however we define that, so that you can have review by your Board of County Commissioners, your city, your school board, and then ultimately the district court. And Mr. Reviser, would it be true that in court we have a system, a definition almost, if you will, that in order to bring scientific, if you will, evidence into the courtroom, it has to meet certain standards, that it has to be widely accepted by the scientific community. It has to be kind of all those things that are already in subsection E. I know we had talked about earlier that accepted scientific means isn't defined in law, but I believe we do have rules of evidence statutes that govern, you know, the Fry test, the Daubert test for expert scientific opinion. And with those, wouldn't those apply when we're looking at the orders that have to be based on accepted scientific means?
Thank you, Madam Chair. This is Jason Thompson with the revisor again. I think your point is clear in a district court action. Yes, Chapter 60, where your amendment made clear earlier today, those hearings would be conducted. You know, the rules of evidence would apply, and so there might be that burden at that point. But these definitions outside of Section 4 are all for the use of a board or a city governing
Before
body
you
or a
would get
county
to
governing
court.
body.
Right, right.
Right. And so they would be well advised to follow scientific evidence that might be admissible in court. But I don't know that that's the same standard they're looking at when they're making these orders right now. I just don't know enough to say for sure, but I can say you're right. The rules of evidence would apply under Chapter 60 once they get to court. So that could be an interesting burden placed on them if they haven't done their proper,
Sure, so what we might need before the court, before you got the action to court and you're in front of the boards and things, is a definition like subsection E in the balloon. So that's kind of what I'm hearing from the discussion. So is there any further discussion on the motion? Seeing none, then, would you like to move your amendment then?
Yes, I'd like to move the amendment striking the last two sentences.
Committee, you've heard the motion. All in favor, aye.
Aye.
All opposed, no. The motion passes. Do we have another amendment ready to work? And I will say the motion, yes, the motion that we got it. Striking those. Yes, Senator Wilborn.
Thank you, Madam Chairman. If you'll turn to page 7, whoops, I got to better spread these. Have we shared them yet? We haven't. Okay. We'll turn to page 7 on Senate Bill 273 on line 5 and insert the words perform an inquiry, study, or investigation for the legislature pursuant to and 46-101 et al. And amendments thereto related to emergency management. Basically, that is nothing more than a subpoena power. And a term that I learned on this is there's a term called ducis tecum, which means subpoena the documents and all the working papers so that there is adequate information to have before the council. And that's the simple amendment. Thank you.
Thank you. And I see the revisor pulled up the amendment that is called investigating. Committee, any discussion, questions for the carry of the amendment? Yes, Senator Haley.
How is this, thank you, Madam Chair, or how is this different from what they can do already in terms of the LCC or the Joint Committee or the Finance Council? I mean, don't they already do that? I mean, isn't that, is that not customary with what the existing power is?
If that's probably a question for the revisor, I'm not sure. And then we would then be giving subpoena power to the Joint Committee as well as the Legislative Coordinating Council. Is that right, Mr. Thompson?
Thank you, Madam Chair. This is Jason Thompson again. I wasn't able to put a lot of research into this one, but I did talk to a couple of attorneys in our office, and the statutes in 46-1001 at SEEK do allow for any committee or of the legislature to be deemed an investigating committee for these purposes. And so by making this reference, we're just making clear that the newly created joint committee is one of those kinds of committees for the purposes of performing their emergency management related purposes. So they may have it already, but this makes it clear that they do have those powers.
Thank you.
Thank you. Yes, Senator Haley.
Just saying thank you, Mr. Thompson. Thank you, Madam Chair. Appreciate it.
Any other discussion or questions? Senator Corson? All right, sorry, it's hard to see over there. Yes, then I will entertain a motion.
Madam Chairman, I so move the amendment.
And a second from Senator Gossage. Thank you. Committee, you've heard the motion. All in favor, aye. All opposed, nay. The motion carries. Do we have another amendment? Senator Baumgartner.
Thank you, Madam Chair. I have,
And what's the name of it once you would get
it's
started?
called schools.
Schools. Okay, thank you.
Madam Chair, I think you and the committee remember that there was some question about the reference within the bill of a school within a school district. And so what this amendment does, it addresses those questions on page 20 and 22. And quite clearly, what it simply says is any school or attendance center of such school district. So it makes it very clear that it's an attendance center of the school district. And then on page 22, it also indicates that it's in a school district, attendance center, or non-public school. So we made it as clear as possible for people to know exactly what we're talking about when we're talking about actual facilities. Thank you, Madam Chair.
Thank you. Committee, questions for the reviser or for the carrier of the amendment or discussion? I have just one question for clarification. Attendance center, does that have a special meaning other than it's a physical location where students attend, or it's a building then where students attend? Is that?
It is, and thank you, Madam Chair. And ironically, yesterday when we were talking about the school within a district, when our reviser was addressing that issue, he used the term attendance center. And that's how I jotted that down, because that is what we use when we reference buildings that schools use for children and adults to attend.
Very good. Just wanted to clarify that for those listening and the committee. Yes, Senator Gossage.
Yes, so then there is a definition of attendance center somewhere.
Well, Mr. Thompson, do we have a definition of attendance center in statute somewhere?
Thank you, Madam Chair. This is Jason Thompson again. Yes, I referred to two education revisers that helped me draft this one. And this is the wording that appears in 48-925B that's repealed by this bill, where you prohibited the closure of schools or attendance centers by a governor's executive order without the approval of the State Board of Education. So these provisions are essentially replacing that. So we tried to echo the same language about a school or an attendance center, which is something some school districts have but are not exactly schools. And then we also clarified non-public schools to be clear in these certain provisions that they're not included either. All approved by our education folks who know this area much better than I do.
Okay, it's so attendance center means literally what the words say, a place where students attend. It doesn't have some special meaning other than what we've just said, correct? Because if it has some other special meaning, I would think, need to clarify it here in the statute so that it's not confusing for those who are going to be applying this and living with it, actually. So well, with that, is there any further? Yes, Senator Pyle.
For adjacent reviser, would, under new section 5 on page 9, where the amendment says, or attendance center of such, Jason, is attendance center of such school districts referencing only the public school attendance center, or will that embellish all school districts, all attendance centers, if even private or religious schools?
Mr. Thompson?
Thank you, Madam Chair. This is Jason Thompson again. That was the particular question I raised with our education revisers, and the opinion we have is that by saying anything of such school district, it means within the jurisdiction of that school district only. So if they're not in their jurisdiction, they're not covered by this language.
So it does not cover the religious or private schools.
Mr. Thompson?
That is my understanding, yes.
Thank you.
Thank you. Yes, Senator Baumgartner.
Thank you, Madam Chair. I apologize. I just noticed a change. If you look at the second balloon on page 9, so it would be essentially on page 27, we have the word such in that second balloon, and we don't need the word such.
You're right, it's a double. We would need then in the balloon to strike the such in the second of those 3 balloons on page 9 of the amendment there. Is that correct, Senator? Yes.
Correct.
Yes. Senator Gossage.
So then we're to understand that community colleges, which is mostly what we're saying here, as far as attendance centers, are fine with being under the, because it says only the Board of Education of a school district shall have the authority to take any action. So they would be under the authority of the local school district, and they're fine with that?
Is Senator Baumgartner?
Thank you, Madam Chair. This only deals with our school districts. I have a separate balloon that addresses community colleges.
So attendance, I'm sorry.
The attendance center is just for the school districts.
Okay, because I'm just thinking students attend
Right.
other things, so.
And attendance center is a term of art in the education statutes, if you will, in the education community too.
It just occurred to me, it says of such school district, so that's the purpose of the of such to say. So I'm fine with that. Thank you, Madam Chair.
Sure. Any other discussion or questions? Is there a motion? Senator Baumgartner.
Madam Chair, I do move my balloons, and noting that we amended that second balloon to strike the word such.
Yes, Senator Thompson. We have a second. Thank you. Committee, you've heard the motion. All in favor, aye. Opposed, nay. The motion carries. Do we have any more amendments? Senator Baumgartner.
Thank you, Madam Chair. I do have an amendment. It doesn't have a name. I will name it the community colleges. Oh, who do I give it? There, I'm sorry.
Would you like to explain your amendment, Senator, or have the reviser?
I'm happy to explain it. There is one very large attachment when you receive it on the last page, but I will talk about what will be a little bit of the more simpler components, and that is starting on page 8, where it says a person aggrieved by an action taken or an order issued or a policy adopted by the Board of Education of a school. And that's where we drop in, or by the governing body of a community college or technical college as described in section 6 and amendments thereto. And then it goes on to say a hearing in district court of the county where such school district or college is located or in which the person resides. And then we add the attachment, and that is on the last page. And what that really does is it works to codify that responsibility of the community college trustees. Item number 2, so C2, during any such state of public health disaster or emergency, the State Board of Regents, the Governor, Department of Health, and it goes on to include the Kansas Association of Community College Trustees, the Kansas Technical College Association, or other state or local unit of government may provide guidance. And what it does is it does step through what that process of redress would be. So if an employee or a student aggrieved by any action, order issued, or policy adopted by the governing body of a community or technical college, so within 72 hours of receiving a request, the governing body shall notify the aggrieved party of the scheduled hearing date. So this is a little bit different from what we have with the courts, because it allows them that ability to schedule. So if there might be multiple, they can schedule at one point in time, or schedule a point in which the trustees are all together. It also includes that an employee or student aggrieved by a decision of the governing body may request a hearing in district court. And so it steps it through that process. So like I said, the only difference is they will notify them within 72 hours of receiving the request when that hearing would be. And I guess as a final point, Madam Chair, the 19 community colleges as well as the technical colleges do agree to this language.
Thank you, Senator. Any questions, discussion? Yes, Senator Pyle.
Thank you, Madam Chair. In the bill, local jurisdictions, if I understand the bill right, we're giving local jurisdictions the authority to do up to whatever the order is or less. Is that correct?
That's correct.
And if I understand this amendment will be broader. We can be given them full authority to do whatever. Is that correct?
That's probably a revisor question, Mr. Thompson.
Madam Chair, this is Jason with the revisor. I'm sorry, not quite sure I followed the question. Could I have it repeated a little more clearly?
Sure, Senator, if you could repeat the questions.
Yes, Jason. My understanding of the bill is that we give local jurisdictions, except for school boards, but we give local jurisdictions, counties, whatever, authority to do up to the same as the orders or less than what those orders are. But my understanding of this amendment, it would be giving them full authority to do whatever, take any action. Is that correct?
Mr. Thompson?
Okay, thank you, Madam Chair. This is Jason with the revisor again. I think the easiest way for me to answer this, and I'm not sure if it's as responsive as Senator Pyle would like, is that this section matches the school board section in every way. These bodies would be given the same power over their institutions that school boards are given over their institutions. The language should be nearly identical, and the only difference is with the 72-hour hearing provision down in subsection C2. That's the only difference I remember drafting from section 5 of the bill.
Go ahead.
Well, explain, please, the governance of a community college. Are those members of those boards elected to the public at large?
Mr. Thompson?
Thank you, Madam Chair. I do not have an answer for that. I would not be competent to answer without doing a little research. It's just not my area of law. I'm sorry.
Does anybody know the answer to that question?
Madam Chair,
Senator Baumgartner?
they are elected. The only exception would be if there's a vacancy, like other governing bodies, it would be the trustees that
They're
fill.
elected, but are they elected by the public at large?
They are.
Just within what district? What are the boundaries of a community college district? That's what I'm trying to.
Community colleges are, the trustees are whatever is the home district. Some community colleges, their district represents multiple counties, but it is the county where the institution is located where they are elected. The exception to that is Cali County. I believe you were on Education Committee when they came and they wanted a separate taxing entity from the neighboring county. And as a part of that process, what they did is they added a trustee that was elected from that neighboring county. So they grew the county, or they grew the board by one person, and that's because that individual represented that new county that was putting in some tax dollars.
Okay, thank you. I appreciate the clarity because, you know, if we're going to give them the same full authority as we're giving the school board, I want to know that they're elected, and I appreciate that. Thank you.
Any other discussion or questions on the amendment? Seeing none then, is there a motion? Senator Baumgartner?
Thank you, Madam Chair. I move the amendment.
Thank you, Senator Gossage. Committee, you've heard the motion. All in favor, aye. Opposed, nay. The motion carries. Do we have another amendment to work? Yes, Senator Thompson. If you.
Very simple, very, very simple.
Would you like to explain the amendment or have the reviser?
I can do it. Let me just find it.
Sure.
Madam Chair, could we identify which amendment so I can get that shared and posted?
Sure. It's National Guard, he had said. Thank you. National Guard, yep.
Yes.
Thank you.
Turn on my mic. Nothing in the Kansas Emergency Management Act shall be construed to, and in this case, a fact or otherwise, or other, during a declared state of emergency, basically affect the jurisdiction or responsibility of police forces, firefighting forces, and I wanted to add the Kansas National Guard. I have a friend who's a colonel in the Guard, and he looked over this bill, felt like they needed to be included in this group. And so with that, I will stand for any discussion.
Thank you. Committee, any discussion or questions? Seeing none, is there, oh, Senator Haley.
So who does, Madam Chair, the National Guard, aren't they a direct arm of the state government, unlike the others that are enumerated? You know, police forces, firefighting, et cetera, et cetera. The Kansas National Guard, the chain of command, I'm thinking, is indeed, well, they serve, I mean, the commander-in-chief is indeed the governor, if I understand it correctly. And if that's an order that comes from the commander-in-chief, in this case, the governor, would this then enable a member of that force to be able to waive the ultimate direct involvement or command of their commander-in-chief, I guess is what I'm saying, since commander-in-chief is the governor of the National Guard, unlike police, firefighter, et cetera, et cetera.
Mr. Reviser, Mr. Thompson, are you able to answer the question?
Thank you, Madam Chair. I'm not sure that I am able to answer that. I just don't have any information that's helpful.
Senator Thompson?
Yeah, again, I was relying on the expertise of the colonel when we discussed this amendment. I would think basically what it does is it doesn't really restrict the governor so much as it does just allows the Guard to do their duties and responsibilities in a state of disaster, and that the Emergency Management Act shall be, nothing shall be construed to get in the way of them doing their duties during a state of disaster, as I understand his logic for this.
Senator Baumgardner.
Thank you, Madam Chair. I think we should have this clarified, but it is my understanding, because we do have a National Guard post in my district, in my neighboring town. And so they do, they have folks that are there every day. We also have folks that come in on their weekends. And that is not so much, their tasks are not driven by the governor, though the governor can call on them in a situation of emergency. But they can be called to go serve overseas with any type of military activity that we're involved in, and that is not the governor that calls them up to go serve overseas. But I think we probably should have some clarification. I assume that the senator is simply saying that unless they've been called upon by the federal government or by our governor, they would just continue their normal duties.
That's the intent of this.
Senator
I'm
Thompson,
sorry.
go
I'm
ahead.
sorry, Madam Chair. Yes, that's the intent of this. Yes.
Well, I think with the question that's been raised, I think we would need to have clarification whether it's the proper place to whether the amendment is legally proper, if you will. So, I mean, not just policy-wise, but whether it's, would be interfering with chain of command and things like that. Unless the committee's comfortable moving forward, I'll, entertain a motion, whatever the will of the committee is on this one.
Madam Chair,
Senator Thompson?
I'll check into it, and, if we need to bring it on the floor, we can do that, or if we're working tomorrow, I'll try to get an answer for that.
Appreciate that then. So we don't have a motion before us, so there's no need to withdraw the motion. So we will then move on. Are there other amendments to be worked? Okay. All right, Senator Thompson then. And what's the name of this one?
Thompson, this would be, actually, I think it's the Hildebrand Amendment, which is the, on the firearms. I'm not sure what Jason.
It's probably up here in the right corner of the first page in the little box up there.
Oh, there we go. Okay, firearms, yes.
Thank you. Do you want to explain the amendment or have the provisor?
I think I can do it. Basically, again, we are not limiting or otherwise restricting the sale, purchase, transfer, ownership, storage, carrying, or transporting of firearms or ammunition or any component or combination thereof, including any components or combination thereof used in the manufacture of firearms and ammunition, or seize or authorize a seizure of any firearms or ammunition or any component combination thereof, except as otherwise permitted by state and federal law. Basically, it allows ammunition, firearms to continue to be transported and not seized during a state of emergency as per our Second Amendment rights. And with that, I'll stand for question.
Senator Wilborn.
Thank you, Madam Chairman. I will ask the carrier of the amendment one simple question. I assume the way it reads, that means reloading supplies, primers, powders, wads. That's
Senator Thompson.
That would be correct. That would be correct. Any corollary equipment that comes along with firearms, correct.
Any other questions or discussion? Senator Haley.
Thank you, Madam Chair. This is for Mr. Thompson. Isn't this consistent, or is this provision consistent with what what we enacted last year? Is it the same as that language, or is it different than which? I mean, I guess I'm trying to get some clarity there.
Mr. Thompson.
Thank you, Madam Chair. Jason Thompson with the revisor again. According to another revisor who knows the firearms law better than me, so you can see this was very much a team effort today, and always. This is drawn from the restrictions on municipalities, laws they're not allowed to enact. That is where some of this language comes from. So it is something that we have a model for, but this is broader than the current law restriction, which is more similar to what is there in strike type on page 12 already. That is essentially what is in the law that you enacted already. And this would be slightly broader, as Senator Thompson has described.
Senator Haley.
Thank you, Madam Chair. Could Mr. Thompson share with me or with us where is the elasticity that broadens this from what our current provisions are? I'm reading it through as I'm talking, and I think I don't see where we don't have these provisions in place already, but could he share?
Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. So the current provision is just ammunition or sale, dispensing, or transportation of firearms or ammunition. The new provision would also specify purchase, transfer, ownership, storage, carrying, transporting. So all of those words may be encompassed, but are more clearly stated here. Any component or combination thereof may not be covered by the current phrasing. And any component or combination thereof used in manufacturing was the part we were specifically asked to include as part of this request. So I think that's probably the most important difference in the eyes of the person that asked for the amendment.
Finally, Madam Chair and Mr. Thompson, are there similar provisions in our current law and statute elsewhere that has similar language that secures these rights as they relate to Second Amendment or broader? Or is this then too potential change in our current definition? Or is this anywhere else in our current law?
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson again. I'm having trouble with my mute button, but it appears to be working again. Again, not an expert in this area of law. I'm told that this is drawn from some language that cities are restricted from enacting ordinances that can deal with these issues. So that's what I'm told. I can't give you the site. I was unable to find it on my own just now in my quick research on my other screen. So I apologize to the committee. I can't verify that. It's just what I was told by another attorney in my office, that there is some sort of model for this language. And essentially, the request was to add manufacturing as something that couldn't be restricted by executive order. And so in my eyes, it's a straight policy question for you. Do you want it to be broader than it is now or not? And so I guess I'll just stop there.
Thank you. And sure. Any other questions or discussion? Seeing none, do we have a motion? Senator Thompson?
Madam Chair, I move my amendment.
Senator Wilborn, second. Thank you.
Madam Chair.
Yes.
This is Jason Thompson, and I apologize for interrupting. Jenna was able to find the statute for me real quick, just if you wanted to know. 12-16, 124. Firearms and ammunition regulation by city or county. So, thank you.
All right, thank you. Committee, you've heard the motion. Any discussion on the motion? Senator Haley.
Thank you, Madam Chair. Yeah, let me say that there's probably no one in my caucus who is more supportive of Second Amendment rights than I. I think my record clearly speaks for itself on helping that. I am concerned about, in response to the disaster emergency, though, that we are crafting what could be precedent for yet unexplored applications of our current Second Amendment rights and some of the laws that pertain to it. I would prefer to have a clearer understanding of the implications of manufacture of firearms or ammunition. And so I just say all that to say I've been supporting all of these provisions that have coming in, but I just don't really feel comfortable changing or putting into precedent our law until we have it more fully vetted, and will not be supporting this motion.
Thank you. Any other discussion on the motion? Senator Gossage.
I'm sorry, Madam Chair. I guess I didn't fully understand what the reviser was saying. Did he say where this language was, from whence it was taken? I didn't quite understand the answer.
Thank you. Senator Thompson, do you want to respond? Or I guess it was actually to Senator Haley's question. Senator Haley, are you able to respond? Or Mr. Thompson, if you want to clarify for Senator Gossage, you had mentioned while we were talking that you had further clarification on the language and where it might elsewhere be found or not. If you could respond.
Yes, thank you, Madam Chair. Jason Thompson again with the reviser. And yeah, I apologize that I had to interrupt there. I just didn't want you to not have the information before you voted, since it was just asked for and we found it at the last second. The statute is 12-16, 124. So it's in the municipal chapters. And it has the language that no city or county shall adopt or enforce any ordinance, resolution, or regulation, et cetera, governing the requirement of fees, licenses, or permits for the commerce in or the sale, purchase, transfer, ownership, storage, carrying, transporting, or taxation of firearms or ammunition, or any component or combination thereof. So that bit of language about sale, purchase, et cetera, is drawn from that statute. It's the model that was used. And I guess I should point out that it does not say manufacturing, so I'm glad that we looked it up. But the manufacturer of firearms is in this provision, but I don't see it in that Chapter 12 provision. Nonetheless, policy choice for you to make. I just wanted you to have the information that you asked for.
Thank you. As always, Mr. Thompson, appreciate your thoroughness. So thank you for speaking up and providing that additional information. Committee, any other discussion or questions on the motion? Senator Haley.
Thank you, Madam Chair. So the question of, and I'm glad manufacturer was mentioned. We've had in previous years some concerns about new means by which weapons can be manufactured. I remember the debate that we had regarding the outlaw of 3D printers and the licensure of them and how they would, and this legislature has rejected, I believe, 3D, for example, the manufacturing of those weapons and others. You know, I support the underlying tenet of what this measure wants to do. I just don't understand or certainly cannot support going into uncharted territory in response to the concern for emergency declarations and then opening the door, if you will, to yet unvetted areas of concern for this legislature to consider, including but not limited to the manufacture of firearms. If we could, in other words, Madam Chair, if we could stick to the points of where we have established laws and we know where we stand already because it is black letter law or we have something to draw from, I'm good. But it's these areas where we're drawing outside the lines that we have not considered already, again, in this one, like the manufacture of firearms and ammunition, where I become a little uneasy to put a precedent in place and will not then support. Thank you.
Thank you. Yes, any further discussion or questions on the amendment? Senator Wilborn.
Thank you, Madam Chair. In my humble opinion, the term manufacturer could mean commercial and also could mean homegrown loading, reloading of shotgun shells, and the components that go into that are primers, wads, powder, and lead. And I think that broadens it to prohibit the outlawing of those components. So I strongly support this broadening of the term. Thank you.
Thank you. Senator Gossage.
I too strongly support it because historically, and sometimes emergencies have, not necessarily in our country, but in other situations, emergencies have been an excuse to say, oh, it's an emergency, so we need to make sure that we do this, or we oversee this, or we deny this, having to do with firearms. And I have no problem with that language. Thank you.
Thank you. Any other further discussion or questions on the motion? Senator Thompson.
Yeah, and just to Senator Wilborn's point, there are people who actually build their own firearms at home. They have the wherewithal to do so, and we just don't want to restrict that ability.
Thank you. Is there a motion? Senator Thompson.
I move my amendment.
And second from Senator Wilborn. Thank you. Committee, you've heard the motion. All those in favor, aye. All opposed, nay? No. The motion carries. Would you like your vote recorded, Senator Haley? Okay, your no vote is duly recorded. Thank you. Committee, then we're back on the bill, and we have another amendment, it looks like, from Senator Thompson. Do you want to tell us the name of the amendment and explain it, or have the reviser explain it?
I can explain it, Madam Chair. This is called healthcare facilities. And I'll let it be passed out first.
Thank you.
This is fairly basic, but during the course of the pandemic, and particularly early on in the pandemic, there are a number of elective surgeries, elective procedures that were restricted by hospital facilities because they were concerned about the the spread and transmission of the disease, but these were, in some cases, cancer screenings, breast cancer screenings, colonoscopies, things of this nature. And in this case, the intent of this is to put the decision to restrict access to the facility on the facility itself and not in the hands of the state health director or anybody, or a county health director or anyone else. We want to make sure that the medical facilities themselves, if they have the wherewithal to do these procedures, are allowed to continue to do so. And we saw people who deferred cancer screenings and then later on and found out they had cancer, and it may have gone too long. So that's the intent of this, just to, again, allow not only local control, but specific business control over what they can and cannot do in these situations. And I will stand for questions.
Thank you, Senator. Committee, any discussion or questions for the revisor or for Senator Thompson? Yes, Senator Gossage.
I would just like to reiterate a personal story. My sister, who's fine with me telling this story, I've told it many times, had a routine routine elective procedure, which was just a colonoscopy, a routine colonoscopy. And thankfully it was in February before the shutdown in March, because they did find colon cancer. So the doctor had told her, had this been later, and so she started her 12 rounds of chemo that started March, the first part of March. So had this not been, I mean, I don't know that my sister would have lived, because look how long we postponed these surgeries. However, doctors have told me that yes, it should be the facility, because they know if they're being undated. You know, there were doctors that were just sitting around literally playing cards because elective procedures were not coming in. They didn't have COVID cases, but they weren't allowed to have these elective procedures come in. They had to let nurses go or lay off. And so I absolutely support this.
Thank you. Any other discussion or questions? Yes, Senator Corson.
Thank you, Madam Chair. I have a question, I think probably for Mr. Thompson as opposed to Senator Thompson. I think the last sentence makes it clear, but I just want to make sure that the last sentence says any restrictions shall be determined solely by the healthcare facility or healthcare provider. That section starts with talking about the governor shall not have the power or authority. But am I correct, Mr. Thompson, that this would also mean that a city or a county or any other body of government, municipality or otherwise, would also not have that authority? Is that a correct reading of that last sentence? Thank you.
Mr. Thompson?
Madam Chair, actually, I can take that question. I happen to staff health committees, and so I wrote this. If you were to go to the page.
Hold on a second. Stop. Please. Sorry. Please identify yourself. Thank you.
Oh, sorry. This is Jenna Moyer, Revisor Statutes. And if you look to page 12, that's right before this, it says, the governor shall not. And so this would be limited to, the governor cannot, during the stated emergency, restrict the ability of these facilities to provide healthcare services, and any restrictions on those healthcare services would be determined by that facility or the providers at that facility. And I hope that answers the question.
So that would mean a county, city, or other municipality could not, separate and apart from anything the governor decides, those municipal units could also not make those decisions. Is that correct?
Ms. Moyer?
Madam Chair, Jenna Moyer, Revisor Statutes Office, that is not dealt with in this section of law. So this is section 7, it's 48923, and that is specifically limited to what executive orders or what orders the governor can and cannot make. And so that is not dealt with in this section. So whatever the current law is what would be governing.
I appreciate that. I appreciate, and I think I understand the explanation, and it was well done. I think I am still confused on that last sentence, kind of the import of that. I don't know if others share that. I don't know if there's a way to resolve it in drafting. And again, if I'm the only one who has that concern, I think that it's been answered as well as it could. I just am still unclear with how that last sentence interacts with the subpart B that talks about the governor, but that last sentence to me feels broader than the governor. But again, if I'm the only one with that concern, then we can move on. And I appreciate the explanation, and thank you, Madam Chair.
Thank you, Senator Corson. Senator Thompson.
Yeah, and again, 48.923 does deal specifically with the governor. To be honest, you bring up a very good point. Maybe we should add this balloon to the section that deals with the counties and the cities a little farther down in the bill.
Sure, Senator Corson.
Maybe I could just, maybe Senator Thompson could explain maybe whether his intent was to include those municipalities, and then that would help us maybe decide if that wording is what we wanted. Was the senator's intent to include or not include, and that maybe could help us.
Right, and I think without the last sentence of the balloon, we're talking about the governor shall not restrict, and then the last sentence talks about restrictions. So, and is that part of the confusion that of the balloon? Yes, and so maybe the last sentence of the balloon belongs in the section where local authorities have the ability to restrict, because we're operating under where the governor does not have the power of authority. But I'll leave it up to the carrier of the amendment to determine. Senator Thompson.
Madam Chair, I was focusing solely at the time on 48.923 and did not consider that. However, I think under further consideration that this is something we should, and I would be very happy to add, work with the revisor to add this as another amendment to keep this clean, and work with the revisor to add that section in the bill that would also address the ability of the county or city to make such rulings as well.
Senator Thompson, I'm wondering, based on Senator Corson's questions, whether another amendment would be necessary to deal with the local authorities and who aren't the governor, and with or without that, it's the last sentence of the balloon, whether that makes sense to the committee to keep that there, because the balloon is talking about there shall be no restrictions, and then the last sentence says any such restriction. So, and maybe that's a question for the reviser, that are we being consistent if we keep the last sentence of the balloon there? I understand the intent, that if there are going to be restrictions, it shall be determined by the healthcare facility, but where we're operating under Section 7 of the bill, there are no restrictions permitted from the governor. So that's kind of a question.
If I may answer that.
Sure, Senator.
I see where the conflict is. So perhaps a small rewording of that would be either the facility, healthcare facility or healthcare provider, and he says, shall determine, well, I think you're right, let us restrict the ability. I think we would be okay with striking the last sentence, but I want to make sure the reviser would agree with that first, because the intent is to allow them to make those decisions, and if the reviser has a suggestions how we might more articulately word that, I would be certainly open to that.
Thank you. Mr. Thompson?
Madam Chair, it'll be me again, Jenna Moyer, Reviser Statutes.
I'm sorry. I
Yep,
apologize,
no, that's
Jenna.
fine.
Sorry.
I would be completely fine with striking the last sentence. Legally, it means the same thing. It was just providing extra detail that the requester had asked for. And so if you strike the last sentence, any restrictions about providing healthcare services would be made in the manner that they're usually made, which would be exactly what's written here. So it would just go back to the default position in just the practice of the healthcare facility, how they would limit their services as necessary for the patient.
So maybe a compromise to keep it more clean, if you will, or the intent, strike the word such from that last sentence? So that even if you have another body that's placing restrictions, actually that wouldn't allow any restrictions then by any entity other than the healthcare facility or healthcare provider if you struck the word such.
If I would be very happy with that, if that opened it up to also the county and the city not being able to do, obviously my intent was looking at 48,923. However, I think the true intent was not to restrict access to those healthcare facilities unless they themselves determined they were unable to do those procedures either for safety reasons or staffing or capacity. That was the original intent of this balloon amendment. So I'd be very happy with that if that would clean it up and do the job.
Question for the reviser, Ms. Moyer. We talk in other sections of the bill regarding abortion clinics and things. How does the proposed wording of that last sentence of the balloon in the healthcare facilities amendment, if we struck the word such, would that allow abortion clinics to, I guess, restrict or regulate or whatnot as well?
Thank you, Madam Chair. I'm Jenna Moyer, Revisor Statutes Office. And I think Jason's got a phone call from Gordon, but if he were to go up just to page 12 of the bill, it has section B. Thank you, Jason. It says notwithstanding any provision of law to the contrary. And so every restriction in this section says if there's another statute of law that deals with this, that you have to follow those. So any restrictions related to abortion provisions this would not change any of that.
Thank you. Thank you for clearing that up. So then, committee, do we have a motion or further discussion?
Just
Senator
one
Thompson.
quick question for our revisor, Ms. Moyer, if she would. Jenna, do you believe that I also need to duplicate this balloon amendment farther down to cover cities and counties?
Ms. Moyer? If you're speaking, we're not able to hear you.
No, Madam Chair, Jenna Moyer, I'm thinking on that issue,
Oh, sure.
and I might punt it to Jason because I don't know the statutory authority of cities and counties. I don't even know if they have that authority in the Emergency Management Act to do that.
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson with the reviser, back again after talking to the actual reviser. I apologize, committee. I had to take the call from the boss. I don't know if it needs to be duplicated. The issues down below in the city and county are about health orders restricting certain things, and we don't have a lot of these same restrictions that are up here down there. For example, the ammunition one, the firearm one, not down there. Let me ponder it maybe for a little bit longer if I could while you have discussion, but I don't know that it's necessary.
Sure. Go ahead and ponder that. So thank you. Further discussion on the amendment, and if not, then I do believe we had a motion and a second, or
I have
Mr. Thompson,
not, I have not made the motion yet.
okay,
but
very good. So without the motion, then we don't need to withdraw it to go to the next amendment so that Mr. Thompson can ponder a little further, if that's all right. Is there another amendment to work? Yes, Senator Wilborn.
Thank you, Madam Chair. This has to, and it just was handed to me. I don't know the history in depth, except it shortens the time frame. I'm going to turn to the revisers, either Mr. Thompson or Ms. Moyer, as relates to page 4. Where it was modified on line 11 to strike the first 5 words, not less than 24 hours after submitting, and inserting at this time. The proposed executive order to the Attorney General pursuant to paragraph 2, the governor shall submit such an order and insert the words chairman and vice chairperson of the joint committee.
Yes, thank you. And it's called EO review for the revisers.
Oh, excuse me, I did not see that. Thank you. Good. I have some clarification, Mr. Thompson.
Go ahead, Mr. Thompson.
Thank you, Madam Chair. This is Jason Thompson with the revising again. I will pause my pondering. The EO review balloon. Okay, I have it up here now. Essentially, by changing this provision in new section 1, the submission, let me scroll up one screen. The submission by the governor of the executive order to the Attorney General would happen concurrently with the submission by the governor to the Joint Committee on Emergency Management. So that's what that first change would do. So rather than waiting 24 hours after submitting to the Attorney General, she would submit, or the governor would submit the proposed executive order at the same time to both the Attorney General and the chairperson and vice chairperson of the Joint Committee. And then not less than 24 hours after receipt of that order, or at any time after the Attorney General provides the opinion, if it's less than 24 hours, the chairperson of the Joint Committee is then required to call their meeting to review the order. So it could happen at any time after 24 hours, if that's what they need for the Attorney General's opinion to come in, or it could happen before 24 hours if the opinion comes in within a couple hours or 12 hours or whatever the case may be. That is the amendment.
Thank you, Mr. Thompson. If I may add this is in response to the governor's complaint that what we had was slowing it down. This speeds it up.
And thank you. And I think this also addresses a prior amendment that we heard and voted on from a senator. My question is, the fourth balloon says not less than 24 hours. So there has to be a mandatory 24 hours unless it can be reviewed earlier than 24 hours. But the default is not less than 24 hours. Is that right, Mr. Thompson?
Thank you, Madam Chair. Yeah, Jason Thompson again. Yes, the default is not less than 24 hours after receiving the order. And that is just like in the current provision there, or the current proposed provision, not less than 24 hours, to give the Attorney General the 24 hours provided in the subsection right above. But they're allowed to go earlier if the Attorney General goes earlier. I did ask about whether there should be a back end limitation, within 48 hours after receiving the Attorney General's opinion, or some other time period, and that is a policy choice you can make. But for purposes of this, it was just to provide that they had to wait for the Attorney General opinion, at least for 24 hours, and then they may call their meeting at any time after that.
Got it. Okay, unless the Attorney General acts sooner. So, and it does seem to speed it up at line 11 there. It says at the same time. So thank you. Committee, questions for the reviser or the carrier of the amendment or other discussion? Senator Corson.
Thank you, Madam Chair. I had one wording suggestion that I believe is intended as a friendly suggestion to this amendment. And I do appreciate this amendment because it does address an issue that I raised earlier. So I'm appreciative of this amendment being made because I think it addresses and is improving an important part of the bill. I was wondering if the carrier of this amendment would view as friendly if we went in line 16, where it says committee shall call and if we would change that to committee shall hold, my thinking, and the reviser can correct me if I'm wrong, but when I think of call, we could call a meeting, but we could actually have the meeting in 2 weeks. I think what I'm thinking all of our intent with this is to actually have that meeting as expeditiously as possible so we can decide whether or not to implement the proposed executive order. So I'm intending this as a friendly amendment, and I think what is the spirit that the amendment is being offered in. Thank you, Madam Chair.
Thank you. Mr. Thompson, is there a specific procedural legal meaning to the word call as it's used in line 16? Like a parliamentary procedure?
Thank you, Madam Chair. This is Jason Thompson with the reviser again. No, I don't know that there necessarily is, other than this meeting is scheduled to occur. That would be what happens when you call a meeting on the floor, for example, but then you announce when. I believe this discussion has been had off and on about whether there should be a word in there or not. I think it is a policy question, and if you'd like a cover to make sure that they're actually holding the meeting, we can certainly do that.
Thank you, Mr. Thompson. Senator Wilborn.
Thank you, Madam Chair. First blush, my opinion is that this does help, again, accelerate the process, but that's my first brush impression. Thank you. I think it is friendly. Thank you.
Thank you. Senator Haley.
I'm just trying to understand, can everybody get together within a day? Thank you. Will everybody be able to get together and meet within a day? I guess they're all ready, everybody can get together within a day. I mean, is that humanly? Oh, that's right. It can be done.
Still, though, it's a concern. Can we really get together within 24 hours? Can you even contact everybody within 24 hours? So, yes, Senator Baumgartner.
Thank you, Madam Chair. I think we do identify already what constitutes a quorum. And I think that we, again, need to think about what has and hasn't happened in the past. When there have been other emergencies, natural disasters, people are contacted immediately and they begin responding immediately. What didn't happen when schools were shut down. So one of the first steps with COVID is there was not this communication. There was not this process. There hadn't been that process for other executive orders. So again, I know that we keep focusing on what if there was a nuclear meltdown, but let's look at what has really happened and what we're also talking about. We're talking about executive orders. Not the declaration of an emergency, but we're talking about executive orders. And how many executive orders have we had since mid-March? And I think that you would be very hard-pressed to find any of those that had to be made in less than a 24-hour time period. Thank you, Madam Chair.
Thank you, Senator. Mr. Thompson, just a point of clarification. We've talked several times, it's been mentioned, nuclear disaster. Is that something that just a moment, please. Just for my clarification and for those who are listening, is a nuclear problem or a meltdown or something, is that covered by the bill we're working on? I think we're talking about infectious diseases and contagious diseases. So correct me if I'm wrong, but I don't think the nuclear area is something that would be governed by this bill. Is that correct?
Thank you, Madam Chair. This is Jason Thompson again. I was just going to read you the definition of public health disaster again, because remember, that's the key here in section 1. Public health is just the threat or imminent threat from infectious or contagious disease that is human to human transmissible, but does not include foodborne illness. All other disasters, such as natural, man-made, fire, flood, earthquake, etc., are all regular disasters under 48-9.4.
Okay, so that wouldn't be specifically under this bill. Is that right, Mr. Thompson? The radiation, fallout, nuclear stuff, that would be elsewhere, not this bill, right?
Thank you, Madam Chair. This is Jason Thompson again. I feel like I'm being cross-examined, but no, fair enough.
Sorry, I'm just trying to be clear in
No,
my
that's-
questions, and so get to the point so there's no confusion about the question. I apologize.
No, and I apologize. It's fine. All levity, I assure you. Yes, I mean, my understanding of the carve out that we created in this bill from the definition of disaster is very narrow to infectious or contagious disease and does not even include foodborne illness. So I have a hard time straining the definition of public health disaster to include a nuclear disaster. I suppose I heard the arguments that some might make for that, but the definition of disaster seems to handle that kind of disaster, whereas public health disaster does not seem to include that.
Okay, thank you, Mr. Thompson. I apologize, committee, for the break, but it had come up a couple of times. And the default about the call or hold a meeting, the default is not less than 24 hours after the receipt of the proposed executive order, unless the Attorney General provides an opinion prior thereto. So anyway, with that, any other discussion or questions on the amendment? Seeing none then. There was discussion about possibly changing a word on line 16 on page 4. That would be a conceptual amendment at this time. So we're not going to work the conceptual amendment at this time, but is there a motion regarding the amendment? Senator Wilborn.
I so move the amendment.
Second, Senator Gossage. Committee, any discussion on the motion? Seeing none then, all those in favor, aye.
Aye.
Opposed, nay. The motion carries. Committee, there was a proposed conceptual amendment. There was some discussion on it. We don't have a motion on it. Do we want to have further discussion on that without having a motion at this time?
Madam Chair, if I may, I will leave it to the wisdom of the committee. However, I thought it added expediency, and but I can also see where your feet are held to the fire, and maybe it's not reasonable, but I'll leave it to the wisdom of the committee.
Thank you, Senator. Committee, we're going to stand at ease for a few minutes so I can check on some amendments with the reviser. If you'll excuse me, and we'll stand at ease for a few minutes. Thank you. Committee, thank you for standing at ease while I cleared up a few things. If we could hear from Mr. Thompson, the reviser, if we have just an update on, we were looking at the, well, let's finish with what we were talking about on the amendment, the EO review that we just passed, and there was some question about call or hold a meeting and whether call has certain parliamentary procedures and significance and whether we wanted to change that or not. There was some discussion from Senator Wilborn and others. So it would be a conceptual amendment if we were to so move or anything. What's the, do we have a motion? I'll entertain a motion if that's the will of the committee. Senator Corson.
Thank you, Madam Chair. I would make a motion for a conceptual amendment on page 4, line 16, to change call to hold. Thank you, Madam Chair.
Thank you. Is there a second? Senator Gossage. Before we proceed, Mr. Reviser, is that an amendment that's something you can do were it to pass, because it's a conceptual amendment and it's not written and prepared? Is that proper and in order.
Thank you, Madam Chair. This is Jason Thompson with the revisor. I follow. I can certainly prepare that if the chair is willing to allow it.
Thank you, Mr. Thompson. Committee, any discussion on the conceptual amendment? Yes, Senator Haley.
I'm in an odd position here, Madam Chair. Certainly appreciate the carrier of the amendment and his position. I guess I just am concerned about the ability for everyone to assemble and to meet within a 24-hour period. I know that we do have the electronic option now, so that certainly does ease a little bit of my concern because we can meet by Zoom at a moment's notice. But I guess that joint committee, should this pass, would be suited up and know that they must be prepared to meet at least electronically at a moment's notice to consider these. And so I'm trying to talk myself down off the cliff of dissent. But I'm still a little bit concerned about it, and I'll let it pass over my my unawareness of its ability.
Thank you, Senator Haley. Any other discussion on the conceptual amendment? My thought is that without discretion, we are providing a committee no discretion. The chair has no discretion. And when we're dealing with an emergency, sometimes discretion of the chair or other elected officials, these are elected officials that comprise the joint committee. So with the conceptual amendment, we would be removing discretion from the committee about whether to hold it or not hold it or when. And but they would still have to call the meeting, so it would be set for a certain time and in accordance with the judgment of the joint committee chair. So those are my thoughts, but anyway, yes, Senator Wilborn.
Thank you, Madam Chair, for your thoughts. Now I'm conflicted, but you made a good point again.
Thank you. Any other discussion on the conceptual amendment?
Madam Chair. This is
Yes,
Jason.
yes. Mr. Thompson.
Jason Thompson with the revisor. And just to clarify earlier, I think I misunderstood from the earlier discussion about call and hold to the new version maybe being just hold. I would recommend that you go with call and hold because the meetings are on call of the chair. So it probably needs to be both call and hold just to be perfectly safe.
If the intent is to hold the meeting within not less than 24 hours after the receipt of the proposed executive order. We need to say call and hold if the intent is to hold the meeting not less than 24 hours after receipt by the committee of the proposed executive order. Is that correct? Mr. Thompson.
Chair. Yeah, Madam Chair, this is Jason Thompson. Yes, I think the current word call may not mean hold, but with just hold, we lose call, and call seems to be important because meetings under this section or under section 2 and all meetings really of committees in the legislature are on call of the chair.
Right. Thank you, Mr. Thompson. And again, committee, I understand the intent of the proposed conceptual amendment. And again, my concern is then you're removing all judgment of the elected officials in the joint committee. So, but any other further discussion on the conceptual amendment? And seeing none then, all those in favor, aye. All those opposed, nay. Okay, I'm sorry. Let's, to be clear then, the motion is whether to amend Senate Bill 273 on page 4 at line 16. Actually, Senator Corson, if you want to make the motion, since we've had a suggestion from the revisor, let's, do you want to withdraw your motion and we'll entertain another one?
I would like to, thank you, Madam Chair. I would like to withdraw my initial motion. I will
And
make.
hold on, we have to see if the second is withdrawn as well. Is the second of the motion withdrawn? It is, okay, thank you, Senator Gossage. Senator Corson.
Thank you. I will make a new motion, which is that on page 4, line 16, that we say committee shall call and hold a meeting of the joint committee. Thank you, Madam Chair. That is my motion. I will move that motion.
Thank you. Do we have a second? Okay, Senator Bowers seconds the motion. Committee, any discussion on the motion? Yes, Senator Baumgartner.
Thank you, Madam Chair. I think that the discussion has been helpful up to this point in time. I would have to concur with you that it is very prescriptive to be telling leadership of a group, a committee, just exactly how soon they're going to be doing everything. I think it's appropriate to say that they will call within a time period, but to say it's going to be held at a certain time period, I think that's overly prescribing.
Thank you, Senator. Other discussion on the motion? Seeing none then, you all have heard the motion. All those in favor, aye. Opposed, nay. Let's have division then. It's too difficult to call. So then all those in favor of the motion, raise your hand, please. Seeing 3 hands, all those opposed, raise your hand, please. Seeing 4, then the motion fails. Committee, we are back on the bill. Does anyone want their vote recorded? Seeing none then. Any other amendments to work other than if we can circle back to the ones where we were having our astute reviser work on the National Guard amendment, and it may be too early for thoughts on that. It looks like it is, but Senator Thompson has a thought.
Yeah, I think what I'm going to do is to give the committee time, or give me time to research that a little further. If I feel necessary, I can bring that on the floor. I don't think that would be a big, horrible amendment to try to do so on the floor. I know we don't want to do that a lot, but in this case, I want to make sure that I'm getting it right. So rather than trying to work it today and make a quick decision, I want to have a little time. The only thing I would suggest is if we could get Mr. Thompson's thoughts on the health care amendment that we had put aside for a few moments.
Thank you, Senator. Yes, that was my next one to take a look at if we had any further thoughts from the reviser or direction on the healthcare facilities amendment, whether any language needed to be added under the authorities of the authority of the local boards and commissioners. I think that was where we were looking at whether we needed to add language there or not. Mr. Reviser, if you're in a position to answer, and if not, we will move on to other amendments.
Madam Chair, given the pace we've been at, I haven't really had a lot of chance to look at that issue, but I did look at the 2 provisions down below in Chapter 65 and Section 3, and the limitations provided in the bill are just about the gathering of individuals, the burdening of religious gatherings or activities, travel between counties in one particular case, but none of the other restrictions that are found in the executive order provision that we were discussing earlier, where we might add the healthcare piece. So I don't know that I see a reason for it, but if there's a policy reason that you want it there, I suppose we could do that. I just think there are a number of things that are only really related to the executive order and not these other orders. And I'm just not sure that those bodies have any authority over those facilities. But I can't say for sure. So it's up to you really about whether you want to circle back or just go with the amendment as it was. And so I'll just defer back to the body.
Thank you, Mr. Thompson. Senator Thompson?
I think I would like to go ahead and move that amendment. The only portion I'd like to see is just strike the word such, as we discussed, and if that's okay to do, that the reviser can strike the word such on the next to last sentence, I would move my amendment as amended.
Do we have a second? Senator Bowers. Discussion on the motion. Seeing none, then you've heard the motion. All those in favor, aye.
Aye.
Opposed, nay. The motion carries. Do we have another amendment to work? We do, from Senator Thompson.
Madam Chair, I apologize for my prolific scrutiny of this bill, but I do have another, actually a couple more. Thank you. They never gave me this much time on a weathercast, Madam Chair.
Well, it looks like we are going to be working the amendment called tailoring. So Senator Thompson, if you want to explain.
That is correct. And this again was offered up, I believe, by Senator Stephan to further tailor how accepted scientific reasons are utilized in remediation of infectious or contagious disease. The printout doesn't have the whole bill, but it would be on page 7, line 24, and it basically says that the governing body of a city or city health officer shall not issue an order that substantially burdens or inhibits the gathering or movement of individuals or operation of any religious, civic, business, or commercial activity, whether for-profit or nonprofit, unless such order includes justification of the accepted scientific reasons for such order and how such order is narrowly it's supposed to be narrowly tailored to accomplish remediation of infectious or contagious disease. The intent, I'm certain, was to make it as narrowly focused as humanly possible so that we don't have some broad brush remediation type actions. And with that, that's about all I can say about that.
Thank you,
Madam
Senator.
Chair.
Any questions for the reviser or the carrier of the amendment or discussion? Seeing none, then we probably do want to make a conceptual amendment to fix the word on page 7 from tailed to tailored.
That is correct. I just noticed that. So any misspelling there is narrowly tailed should be changed to narrowly tailored. And I would move my amendment with that correction.
We have a second. Senator Baumgardner. Committee, any discussion on the motion? Seeing none, all those, oh, excuse me, Senator Haley.
Scientific reasons for such order is narrowly tailored to accomplish. The remediation must be then, if this is adopted, it must show that it is a specific, it zeroes in, if you will, on one particular remediation. So would that be on a point-by-point basis for where the remediation is? Madam Chair, or Senator Thompson?
Sure. Senator Thompson.
Yeah, basically it just means that we're wanting justification of why, what accepted scientific reasons they're using to justify the remediation by narrowly tailoring their focus. I think it's just, the intent is to not broad brush this, but in other words, somebody comes out and says, we're gonna make everybody do this, and we just want to narrowly focus, and this was the accepted scientific reasons for such order and how such order is going to be narrowly tailored to accomplish the remediation. In other words, they have scientific evidence that shows if we do X, then we can tailor this remediation down and be very, very focused instead of just offering a broad brush order and then sort out the damage later. I think that is the intent of the original writer of this amendment.
Madam
Senator
Chair,
Haley?
Madam Chair, Mr. Thompson, hey, look, y'all can put this in if you want. I mean, and you might, but it's just, to me, it just descends into a level of pettiness. I mean, I think the original language that says, and how such order accomplishes remediation of such effective sector, it says that. But then to suggest by the adoption of this that it is, quote, narrowly tailored to accomplish, does not necessarily presume that that's all that the remediation order does. So there's just this, I think that this language, once put into the bill, I think it really kind of makes it look petty. I mean, frankly, I don't think it changes the intent of what the underlying legislation wants to do or is designed to do. It's just injecting disbelief or as to whether or not we need them in the first place. And I just don't think that it's really necessary to do. I will ask, Madam Chair, further up, and there is such language already, I think, if it gives you all any, on page 21, it has there already at beginning at line 8 in section B, it says a justification how the order is narrowly tailored to conditions in individual counties and what have you. So you do already have the language in there if it would make you feel better, Madam Chair, that, but it's the county doing it and not in this case a specific, as this would add to it. I just think that we kind of want to rise above the cheap shots, I would hope. But thank you.
Thank you, Senator. Further discussion, Senator Thompson.
And perhaps this was just an attempt to be consistent with the previous language, as Senator from Wyandotte pointed out.
Further discussion, committee. Right, I think we have heard the motion. It's been seconded. So with that, then we will vote on the motion. All those in favor, aye. Those opposed, nay. The motion carries. We are back on the bill. Any further amendments? Oh, and I'm sorry, would anyone like their vote recorded? Senator Haley. His no vote. Yes, thank you. Any further amendments to work? Senator Thompson.
Thank you, Madam Chair. I promise there's only one more after this. I promise. This is called committee membership, Senate Committee on Judiciary. And this arises from the discussion that we had in the special committee on KEMA about getting more voices involved in the process from the start. So this would expand the joint council, as you can see on the amendment, to still would have the president of the Senate, the vice president, the majority leader, the minority leader, and 5 members of the Senate appointed by the president of the Senate to represent state Board of Education member districts 1, 3, 5, 7, and 9, as established under KSA 4-526, And then farther down, 5 members of the House from districts 2, 4, 6, 8, and 10 for the purposes of representing each state Board of Education member district, and amendments thereto. The senator and representative appointed for such representation shall reside in the State Board of Education member district. Basically, this ensures that every part of the state is represented by this joint committee. I realize it is expanding the committee to a larger group, but that was one of the big concerns that we had. And it may help, get more eyeballs on this problem early on, and perhaps even facilitate eventually people to return, the full legislature to return by having that discussion. Unfortunately, during this last pandemic, the LCC rubber stamped many times what the governor was going to do. And it was very frustrating to those of us who were being constantly barraged by our constituents. Can't you get back there? Can't you do something about these executive orders? Can't you stop this, or at least mitigate what's happening? Businesses are being closed. People are losing massive amounts of money. Things are being done, and we didn't understand what we could do. So this really kind of addresses a fairly broad discussion that we had during the special KEMA meetings. And with that, I would stand for any questions.
Thank you, Senator. Any questions for the reviser from the committee? Seeing none then, or do you have a question for the reviser, Senator Gossage?
Just by clarification, I'm counting 18-member board, is that correct?
That's my count as well.
Okay, thank
Yes.
you.
Thank you. Senator Wilborn.
Thank you, Madam Chairman. Along those same lines, I noticed on page 5, lines 39 through 40 there, thereby establishing a joint committee on emergency management consisting of, okay, I see it, 5, change them both to 9. I got it. Sorry, I withdraw the question.
Thank you. Yes, Senator Baumgardner.
Thank you, Madam Chair. I just want to make sure that this remains silent with regard to party affiliation on these additions. Is that correct?
Senator Thompson.
There's no, it's assigned by the Senate President and the, I believe the Senate, the House. Let me make sure about that. I mean, there are no party affiliation designations in here. It would be appointed by the Senate President.
A reviser may be able to help with us.
Yeah, I would
Chair,
appreciate
but
that.
Typically, when we are creating groups, we do work to have some balance of representation. And to say that in a committee of 18, we're only designating 2 members to the minority party does not seem like much of a balance in representation.
And to the extent, I'm sorry, Madam Chair.
Senator
To
Thompson.
the extent we could fix that and make it consistent with how we create other committees, I would agree with the senator from Miami.
Senator Wilborn.
Thank you, Madam Chairman. And again, I have to opine that probably doesn't have a lot of substance other than my life's experience on corporate boards and many other organizations. When you get to 18 people, it becomes pretty unwieldy. I do understand what the attempt here is to represent different regions and sectors of the Kansas economy and the geographical difference, but I'm somewhat bothered by 18. Thank you.
Thank you. Senator Corson.
Thank you, Madam Chair. I have a similar concern about the overall number of size for the exact reasons expressed by the Vice Chair. But if we were going to stay at that same size, I'm wondering if the carrier of the amendment would view it as a friendly amendment if we said of these 5 members, 3 would be appointed by, with respect to the 5 from the Senate, 3 would be appointed by the President of the Senate, 2 would be appointed by the Minority Leader. Same thing with respect to the 5 on the House side, 3 would be appointed by the Speaker, 2 would be appointed by the minority leader in the House. It obviously is up to the carrier of the amendment if they would regard that as friendly, but that was something that came to mind based off Senator Baumgartner's very good point. Thank you.
Thank you. Senator Thompson?
If that's a proper apportionment of the committee, I would defer to the vice chair, Senator Wilborn, on that.
I think it would probably depend on the makeup of the chamber of the legislature at the time, but go ahead, Senator Wilborn.
Thank you, Madam Chair. And again, if I may opine, there are different methodologies in appointing committees. For example, Supreme Court has to be Republican, Democrat, and so the balance is supposedly they're not counting the ideology of, anyway, I'm getting off course. And, but also we apportion members to a committee a little different too, based upon numbers and a formula that is applied. I do think, I don't know what's appropriate, I don't know what's proper, but by going with Senator from Johnson, Senator Corson's recommendation, that then somewhat disproportionately favors it in the minority side based upon the population of the body. So, I understand where he's coming from too, but I do think there needs to be some balance. I just don't have a specific answer right now.
Thank you, Mr. Wilborn. There are apportionment rules for committees. If we need some enlightenment by Mr. Thompson on that, I'm not sure that we do. My question is in addition to growing the numbers, and I understand the concern that we want our elected officials to be involved as much as we can, as much as prudently possible, to be part of these decision-making processes. Is the intent that you're specifically representing the State Board of Education? Is the intent that the elected official, the senator and the representative, they're appointed to represent just the State Board of Education members in that particular district? That would seem to narrowly restricting the authority of an elected senator or representative.
The intent was to just broaden the scope, and in this case, the vast majority of this last pandemic, there was almost no representation of our rural counties, and they didn't have a voice, and it was just the idea was to try to get more voices, more eyeballs on these situations, have a broader discussion, and have the opportunity for more people to chime in. I understand the concern of the vice chair about the size of the committee, but that was the intent.
Senator Baumgartner.
Thank you, Madam Chair. I certainly appreciate, as Chair of Senate Education, I appreciate that we're looking at representation based on school districts. I would like to have us give a little thought to what is the role specifically of this committee that we're forming. And we might be better served to have individuals that represent specific committees. When you're talking about the flow of funds and overseeing funds, you might want to have representation from Ways and Means from the Senate side. If you are concerned about particularly the impact of rural communities, you might want to have someone that's there from the Ag Committee. If you are concerned about education, you might want to have someone from the Education Committee. That is another way to slice the pie, maybe winnow the committee as a whole down from, is it 18 that we decided it was? So I'm not certain about that, but it certainly does lend itself to what is the task of the committee. You may want to have someone, obviously, from the Health Committee. And so these are the kinds of, and you might break that down where we want representation instead of this large number, but we want from the House representation from a couple committees there, from a couple committees on the other. But having formed committees before, it's work that needs to be done, and you need folks with a certain level of expertise to get that work done. Madam Chair, that's just my suggestion.
Thank you. Further discussion? Yes, Senator Thompson.
I appreciate that. And with that, I'm not sure this is ready for prime time. And I would, this is another discussion I'll have with a few people before, and we'll decide whether or not we can bring it to the floor. The intent was more geographic in nature than specific, but I really appreciate the points from a senator from Miami. And I think maybe we can have some discussions about this and see where we go with it.
Thank you. We're back on the bill. Other amendments to work. Oh, one more, another anyway, from Senator Thompson.
I promise this is it for now, Madam Chair. Yeah.
Committee and Mr. Thompson, this amendment is governor authority. And Senator Thompson, do you want to explain your amendment?
I certainly will. And again, this goes back to during the this adds other restrictions on the governor's authority during the pandemics that but only during public health disaster emergencies declared under this section. Cannot order the closure or cessation of any business or commercial activity, whether for profit or not for profit, deem any business or commercial activity non-essential, or direct or permit any public official of the state or any municipality to mandate immunizations or health care requirements or restrictions that violate the Constitution, both the United States and the state of Kansas, relating to personal health decisions or health-related decisions made by a person with legal authority to make such decisions. The reason for this is, again, I believe in these type situations, if you've got a very, very serious health type emergency, it's going to regulate itself. People will be given information and act on that. However, businesses in many cases were closed that should not have been closed, that could have adapted. Small businesses I know who normally had 4 or 5 people in them, were closed when big box stores were open, the Home Depots and the Walmarts. And so in this case, and I believe we've had this discussion, the health director gives guidance, the health director gives suggestions, and then these businesses can make a decision of how they can adapt to conform with keeping their employees safe and their customers safe. This goes to some constitutional rights to make decisions, and we had people had their businesses shut down for so long that we've lost a lot of businesses. And then you've got people who do not want to be told to get an immunization. We're having that national conversation right now with regard to the vaccines. And so this amendment speaks to that and really tries to give people back their own decision-making, their own constitutional rights to make decisions about their safety. Government was designed to, the Constitution was designed to protect us from government tyranny. And unfortunately, many people feel that the government overstepped their bounds in this particular pandemic. As our founder said, you give up a little bit of liberty for safety, and eventually, it's not a good thing. It's heading in the wrong direction. So that is the intent of this particular amendment. And with that, I'll stand for questions.
Thank you. Committee discussion or questions? Yes, Senator Corson.
Thank you, Madam Chair. I had a question for the reviser, I believe for the reviser on Mr. Thompson about C2. I'm just not familiar with or sort of this body of case law, but trying to think of do we have any examples of healthcare requirements or restrictions that have been found to violate the Constitution of the United States or the state of Kansas relating to personal health decisions or health-related decisions made by a person with legal authority to make such decisions? I'm just trying to understand what those words mean a little bit more, and maybe if there might be some examples. I'm just trying to kind of put into concrete terms what that subpart means. Thank you.
Mr. Thompson.
Thank you, Madam Chair. Jason Thompson with the reviser. Conferring with my health folks briefly. I don't have a specific example. I think that's more related to the immunizations, potentially. You do have some rights to maybe not be vaccinated under law. That is what is hinted at before. But I don't know that I have another specific example. Maybe the folks who requested it had something in mind in particular, but the last clause of that clause, decisions made by a person with legal authority to make such decisions, that's more, if you have the capacity to make your decisions, you're allowed to make your decisions. That, I think, was more the point than the first part, maybe.
Thank you, Mr. Thompson. Just for a point of clarification, is there a difference in law between immunization and vaccination?
Madam Chair, this is Jason again. I was looking to Jenna, and since she's our health committee person and she is shaking her head no, those are the same at least under our statutory scheme. An immunization and a vaccination would be under the same sort of category.
Thank you. And Senator Wilborn.
Thank you again, Madam Chairman. And I think I'm going to ask this question of Mr. Thompson. I regret that I'm not more versed in the intricacies of the bill in its depth, but it seems to me, by looking at some of this, that some of this is covered in the meat of the bill to begin with. Am I correct about that, Mr. Thompson?
Mr. Thompson.
Thank you, Madam Chair. It's Jason Thompson again. Subsection 6A or paragraph 6A might be covered by other parts. If I had more time today to look at that, I might have a better opinion for you. Subparagraph 6B, I don't believe is covered. That's more of a specific item, and 6C definitely not covered under this provision, right? This is in KEMA. I'll scroll up one page for everybody following along at home. These are the things that the governor shall not have the power or authority to do under KEMA. So anything in the health order provisions, that's not what we're talking about. These are specific powers for the governor. And that's why I say maybe 6A, but probably not 6B or 6C.
Thank you, Mr. Thompson.
Other questions or discussion?
I mean, maybe
Senator Corson?
Thank you, Madam Chair. Maybe if Senator Thompson could just again speak to C2 with the intent, because Mr. Reviser Thompson talked about immunizations, but I mean, I believe that's under C little I, and I'm, maybe Senator Thompson could talk about that C subpart, double I, what his intent, help me just understand in concrete terms.
Senator Thompson?
Yeah, certainly. I'm thinking more in line of someone who has an IDD child or an elderly person with Alzheimer's, somebody who is mentally incapable to make their own health decisions. In other words, we would not force that guardian to make those sorts of decisions if it were against the conscience of the guardian. And I really am looking to the 14th Amendment, which says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States with regard to forcing vaccines, forcing any requirements or health restrictions. So we didn't see, we just don't want to see, I'm trying to envision any possible abuses of future orders, and I'm not specifically talking about this governor, but I'm talking about any governor in the future. We want to limit their ability to do some things that may be unconscionable for those guardians, or anybody for that matter, and that was the intent of this.
Thank you. All right. Okay, thank you.
Much appreciated. Thank you, Senator, and thank you, Madam Chair.
Senator Wilborn.
Thank you again, Madam Chairman. I am trying to digest this, going through there, and on CI, on immunizations, does that conflict with the statute we have now on the books as it relates to like TB and other immunizations? I'm just asking.
That's
Mr.
a question for Mr. Thompson.
Thank you.
Mr. Thompson.
Madam Chair, I was waiting for Jason.
I'm sorry, Ms. Moyer.
Making sure, this is Jenna Moyer, Revisor Statutes Office, and the current statutes regarding requirements for immunizations, which is just the word that we use in statutes, at least for the newer ones. They require vaccinations for children who attend either a daycare facility or a public school, and there's a list of them that the Secretary of Health and Environment is allowed to adopt in their rules and regulations. And I think there's about 10 immunizations that are currently required just to attend the school. There's nothing in statutes require any immunizations for adults anywhere. And so this would just be during the state of public health disaster emergency that the governor would not be allowed to adopt more vaccination or more immunization requirements. And that would cover children, adults, everyone. So I hope that answers your question. If not, I can clarify further.
May I, Madam Chairman? So, Jenna, Ms. Moyer, excuse me, if I may understand you correctly, then it leaves the immunization statute intact for schools and public, is that right?
Ms. Moyer?
Yes, Madam Chair, Jenna Moyer, Revisor Statutes Office. And yes, again, we would look to the page 12 where it says notwithstanding any other statute to the contrary or any provision of law to the contrary. And so we say, regardless of what those other statutes say, that this can't modify, that this would not modify the existing statutes.
Thank you. I wish that I was better versed in this. Thank you.
Thank you. Senator Haley.
Madam Chair, I wish I were better versed as well. So I guess this is for, I don't know, Ms. Moyer or Revisor Thompson. In reading this, so in other words, so now the committee, the joint committee, if this amendment is adopted, could not bring a recommendation from the joint committee to close a business or commercial activity. They would not be able to supersede that. Just for clarity, that's what this says, that this is a carve out for what the joint committee could find, correct?
Ms. Moyer?
Madam Chair, I'm not quite sure I understand the question, but under this provision of law, the governor, in an executive order or anything, would, even if it were approved by the joint committee, would not be allowed to do anything that's listed in here, including closing businesses.
So, Madam Chair, Ms. Moyer, this then would be, I guess, if this amendment is adopted, then that would be one remedy that they could not find, is to close the business, or, and I'm just don't, I'm concerned about this, because if the committee found that there was a good reason to, I'm not trying to pick on any industry, but they talked about, for example, the meatpacking industry, where there was a tremendous outbreak, and in that area, the spread was found to be more contagious than others. And if, in fact, this committee the Joint Committee were to meet and to say that because the surface of fresh killed animals has been found to, under scientific measures, to convey this particular disease further, but we can't shut down this particular industry. I think that I'm concerned about having this carve out if this amendment is adopted, and if that's how I'm reading it, if I'm reading it correctly.
Is that a question for Ms. Moyer? Or?
I don't know. I mean, I think that's, if someone wants to correct my understanding or misunderstanding.
Sure, sure, Ms. Moyer?
Yep, Madam Chair, Jen Moyer, Revisor Statutes Office, and I would concur with the Senator's interpretation that even if the Joint Committee were to approve an executive order allowing for the closure of businesses, that this statute, or this section of law would be more specific, that it would prevent the closure of businesses regardless of what the Joint Committee found.
Okay. And finally, moving to another topic of immunizations, I don't know, and this is probably one for research. When polio, and I keep looking at my left shoulder because there was polio immunizations that they required. When you're a certain age, some of us still have the mark on our left arm if we're of a certain age, of which I am, but it was widespread and it was implemented to eradicate an illness, polio, among the general population. So I guess from a research standpoint, was that a general mandate for the population that came not from within the state level, but that was a federal mandate, that there would be that immunization against polio? Certainly wasn't that long ago, well, though it was within my lifetime. I guess it's longer than I'd like to care to admit, but many of us are still, you know, bearing the mark of eradicating a deadly disease because it was generally mandated that it was for the public good. So where did that come from? I know it wasn't a state by state. Was that because it was a federal mandate to have that immunization? And I know that's beyond the purview of this bill or maybe your knowledge, Ms. Moyer, but I don't know if that's come up in any discussion before.
Ms. Moyer and then Senator Thompson.
Yes, Madam Chair, I can't speak to, General Moyer, Revisor Statutes Office, and I can't speak to what would have been required for the polio vaccine. All I can speak to is what is currently required by Kansas law, the vaccinations or immunizations required to attend either a daycare facility or a school, and those are currently diphtheria, hepatitis A and B, measles, meningitis, mumps, pertussis, which is whooping cough. I guess there is poliomyelitis in here. So polio would be a current vaccination required in order to attend school. I was looking for polio, not the scientific name. And then rubella, tetanus, and varicella, which is chickenpox. And those are the ones that are currently required for a child to attend either a daycare facility or a school. And those would be found in rules and regulations that the Secretary of Health and Environment adopts pursuant to statutory authority located in 65-508 and 72-6262.
Thank you. Senator Thompson.
Thank you. And again, I want to reiterate, this is only during a human health crisis. And the grave concern many people have is over the rapidity, the very quick nature that these things they play out. In other words, with this particular vaccine, there's something called antibody-dependent enhancement with some of the vaccines that we're getting. And people, if you get that and you're particularly susceptible to it, you get the vaccine, you are exposed to the virus, and that antibody-dependent enhancement kicks in and your own immune system kills you. This is already happening with some of the vaccines now. So the grave concern is that even though many people are very open to taking the vaccine because they'd like to get back to life as normal. There are also a very large number of people who are very concerned about the vaccines, and I think it should come down to personal choice, not a governor's recommendation or a health director's recommendation or order that they get the vaccine. I think, we all have to judge our own particular health risks and decide for ourselves what risks we're willing to take, and that was the logic behind this.
Thank you, Senator. Committee, yes, Senator Haley.
Just to clear up, thank you, Madam Chair. It's been pointed out, and I appreciate the astute insight. I was not talking about the polio vaccine that I took. It was the smallpox vaccine that was mandated. And so from 1958 to 1977, it was mandated to eradicate the smallpox. And that, in fact, it has been wiped out in the U.S. There are no signs of that. And that's the mark I bear to this day. Thank you for the clarity from our committee assistant that it's smallpox, not polio.
Thank you. Committee, further discussion on the amendment. I have a question for the reviser. I understand the intent of the amendment, appreciate that. Regarding section C, C2, it's already, you can't violate the Constitution of the United States or the state of Kansas Constitution, whether we have this language in there or not, right? I mean, is that a yes, Ms. Moyer?
Oh, yes, I was just,
Okay.
yeah. Yes,
Okay,
Madam
right.
Chair.
Okay. If committee, we've been at this a long time, if we could just stand at ease for just a moment, and we'll stand at ease for a moment. Thank you, committee, for standing at ease as I try to get some clarification on the amendment in front of us, governor authority. With that, then, is there any further discussion on the amendment? Seeing none, then, we don't have a motion regarding the amendment either. So we're back on the bill. Do we have another amendment to work? All right, so any other? Yes. Any other discussion on the bill as amended? Okay, I don't see any then. So do we have, committee, a motion regarding the bill as amended? Yes, Senator Gossage.
Madam Chair, I move that we pass the bill out favorably from this committee as amended.
Yeah, okay, so we need a little bit, okay, as amended to report favorably for passage, Senate Bill 273. Senator Baumgartner.
Thank you, Madam Chair. I am willing to offer the second for that, but I'm wondering if it should be Senate substitute for Senate Bill 273 since we have added so many amendments.
Mr. Reviser, is that in order?
Thank you, Madam Chair. This is Jason with the reviser. I haven't had time to consider exactly how many new sections or amendatory sections were added to see if that would really be necessary. But I suppose having a new substitute bill is not a terrible idea. I'm actually not sure which one would be better. I'll have to, generally it's our choice. And I just haven't had time to think about it today in drafting all these amendments. I apologize. I don't have a good answer.
Before I accept the second, just to be clear on the work we did here today, I think we need to go ahead and work the last amendment that we were considering, the governor authority amendment, if the maker of the motion would withdraw the motion. All right, thank you. And the second then as well?
Well, I hadn't made the
You
second.
hadn't made it, okay. We were getting clarification, so, okay, very good. So the motion has been withdrawn, then we are back looking at the amendment governor authority. I'll look to Senator Thompson then.
Yes, I think we're getting that worked right now to amend that to make it more solid legally. What we're going to do, and it's being worked on right now, is amend some of the wording on this, and I can't remember right off the top of my head, but I think with regard to the discussion on the Part C2, as long as we are certain that the Constitution, that was intended to affirm people's ability to say no. The immunization part on C1, we're going to restrict that only to the immunizations regarding the virus or disease in question during the health pandemic. In other words, we're not going to restrict the school's ability to, require children to have the polio or smallpox or whatever. We're going to leave portion B about the business and commercial activity. We are expanding that just slightly to match up with some of the other part of the bill. Again, that goes back to the KEFF structure that was limiting businesses. And I think that's about it. And we've got Mr. Beckham working on that right now to get the wording correct, but we think this will make it much more solid going forward.
Senator Gossage.
Thank you, Madam Chair. Maybe just former English teacher here. But when I read lowercase b, so 4b, notwithstanding any provision of law to the contrary, the governor shall not have the power or authority to temporarily or permanently, and it seems to me like we should strike this 6, and whereas capital A should be a 6. So it would say permanently, number 6, order the closure or cessation of any business or commercial activity, whether for profit or not profit. 7, deem any business or commercial activity non-essential. 8, direct or permit any public official of the state or any municipality to mandate, and then you've got your I and double I or A, B, C as the case may be. That seems like it reads better for me.
Thank you.
I would defer
Senator
to
Thompson.
the reviser on that one.
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson here. I'm not able to follow completely. I think what was said makes sense, but I'm not following line by line at this point in time.
Thank you. I think the comment from Senator Gossage, if you want to repeat just where in the balloon you suggest be struck.
Thank you, Madam Chair. So we would strike what is in the balloon currently, number 6. And ABC would revert to 6, 7, 8.
If I might, Madam Chair.
Sure, thank you. Ms. Moyer.
Okay. This is Jenna Moyer in the Reviser Statutes Office. And the reason why the wording in 6 is during a public health disaster emergency is currently in there is because this section 7, 48923 applies to all types of disaster emergencies. So fire, flood, anything that would be your regular type of emergency. And then what's in this new 6 would be specifically limited to the public health disaster emergencies that we are adding in section 1. So I hope that provides some clarification.
Okay, that does make more sense. Thank you so much. So we would continue then permanently during a state of public health. That's what you're saying. The number 6 says.
Ms. Moyer.
Right.
Sorry, I was just taking a drink of water. This is Jenna Moore in the Revisor Statutes Office. Yes, so it's just another qualification that the governor shall not permanently or temporarily during a state of public health disaster emergency also do these things.
Thank you. Now it makes sense to me. Thank you, Madam Chair.
Thank you. Mr. Revisor, do we have a new version of the amendment ready, or do we need to stand at ease for a minute?
Thank you, Madam Chair. This is Jason with the Revisor. No, I've been sitting here talking to you. I have not had a chance to do a new one, but if you'd like to stand at ease and wait, we can do that. Or if you'd like to work conceptually, I have plenty of little tinkerings I have to do with the, I don't know, 13 or so other amendments, I think, that I have to put into the committee report. So if you give me some latitude to make technical corrections, make things fit together, and the chairperson gets the final call on whether the report is accurate and correct, that's all fine and good. I don't want to hold up the committee's work at this point, but it's up to you. If you'd like to stand at ease, we'll work as quickly as we can to get it on paper, or you can do it conceptually and we'll try to walk through it as best we can.
Thank you. The requested latitude is so granted and given to get through that for the committee report. And if you can follow along with the conceptual amendment, we don't usually do that. We had a short one earlier because it was just 1 or 2 words. And I think at this point we can make an exception as well, as long as everyone can follow along. So with that, who wants to provide to us what the conceptual amendment would state? Is that Mr. Thompson? I'm sorry, would that be Senator Thompson?
Yes, I think we've got it here.
Okay.
We'll read it right off the laptop.
Okay.
Okay, this would be in place of, okay, let me make sure I'm getting this correct. Where are we at? Okay, so another 6A, order that substantially burdens or inhibits the gathering or movement of individuals or operation of any religious, civic, business, or commercial activity, whether for profit or not for profit. So it's it just adds in some of the language that we had elsewhere in the bill and conforms that to that. So that would be 6A. That remains the same, I believe. 6B remains the same. C, director permit any public official of state to mandate immunizations related to the disease named in the public health disaster, and strike section C2. So CI would read immunizations related to the disease named in public health disaster or declaration, disaster declaration. In other words, restricting it specifically to that virus. In this case, it would be COVID-19. And that would be how we would write that amendment.
Thank you, Senator Gossage.
I was just, so then the related to the disease named in the public health disaster, meaning in number 6, is to which it is referring.
Senator Thompson.
During a state of public health disaster emergency declared under Section 1 and amendments thereto, immunizations related to the disease named in the public health disaster, it says, director permit any public official or state of any municipality to mandate immunizations referencing in number 6. Right?
Yes, that would be correct, I believe.
Thank you.
Yes.
Mr. Thompson, are you able to follow along?
Yes, thank you, Madam Chair. Jason Thompson with the Revisor. I believe so. I have 6 is still limited to during a public health disaster emergency declared under Section 1. Capital A is the substantially burdens or inhibits language from the other sections of the bill. I would just copy that. And B remains deem any business or commercial activity non-essential. And C would be director permit any public official of the state or any municipality to mandate immunizations. related to the disease named in such public health disaster emergency declaration. So we'll tie it back to the one currently under.
Thank you. Any discussion on the motion? Seeing none, then Senator Thompson, would you like to make a motion?
I move my amendment as amended for passage.
Do we have a second? Senator Bowers. All you have heard the motion regarding the amendment as amended. All those in favor, aye. All those opposed, nay. The motion carries. Would you like your no vote recorded, Senator Haley? Yes, please, he says. No. Okay, thank you. Then with that, committee, any other further amendments to work? Seeing none, I just want to clarify with the reviser regarding EO review amendment. Did we vote on that and pass that? I didn't mark it on my paper, but I believe we did the EO review amendment.
Thank you, Madam Chair. Jason Thompson with the reviser. I'm checking my notes. I have that Senator Wilborn's motion on the EO review did pass. That is what my notes reflect.
Thank you. And then was the answer that we did need a substitute bill? Was that the answer from Mr. Thompson?
Thank you, Madam Chair. I don't know that it's necessary, and I'm not actually sure if it's better on our process to do it or not. So unless the committee wants a really clean version of the bill that doesn't show the changes the committee just made, those are basically the two reasons. You either want a clean version of what the committee product is, or you want the product as introduced plus the committee changes to show on that product by not doing a substitute bill. So I guess I would prefer not to do a substitute bill, I think, but if the committee would rather have it clean and do a substitute, I'm willing to do that.
If you have a preference, which you've stated, and the committee is all right with that, we can go with that then. So given that, do we have a motion? Senator Haley, some discussion.
Just clarity, thank you, Madam Chair, on Senator Thompson's other one about the representation in different, I don't know, if we just dispose of that, the one that, of course, it does enlarge the number, but it looks at representation in some of our rural districts. What will, maybe I guess I should ask Senator Thompson what his, I kind of like that one, actually. That's why I'm asking.
Sure. Senator Thompson, I believe the question is regarding committee membership amendment.
Let me have a discussion with some people about that and see if we can't work that out. And if necessary, I can bring that to the floor, because I do think that, we can hone that down a little bit, but still get the representation from the rural areas that we need. Yeah, and so I will have some discussions about how we can do that properly.
Thank you, Senator Thompson. Thank you, Madam Chair.
Thank you. Committee, is there a strong preference whether to make a sub for the Senate Bill 273 or not? Senator Baumgartner, did you have thoughts on that?
My thoughts are this is a 21-page bill. I don't think a majority of the Senate has really seen the bill to begin with. We've been working with it, but I don't know that everyone else has really looked at it. I think there is a benefit to seeing a clean bill, particularly when I assume with the amendments, we've added several pages. So I would imagine that we're looking at probably closer to 26 to 30 pages. That was
it clean, and
that was my only reason for asking if we wanted a substitute.
right. I think we'll keep it clean then. If there's a motion from the committee, Senator Gossage, did you have a motion?
Madam Chair, I move we pass out of committee substitute Senate Bill 273 favorably for passage.
All right, you've heard the motion. Is there a second? Senator Baumgartner, thank you. Discussion on the motion. Seeing none then, you've heard the motion. All those in favor, aye.
Aye.
All those opposed, nay. The motion carries. Would you like your votes recorded? Thank you. Committee, that was commendable work. Thank you for your efforts today. And we will need to look at speedy trial tomorrow, so be prepared for that at our regular time and place. Yes, Senator Corson.
Thank you, Madam Chair. Well, first, I want to just thank you and the Vice Chair for shepherding us through a very complex bill with many amendments. I'm very appreciative of your skillful leadership through this discussion. So I just want to thank you and the Vice Chair for that. It's very much appreciated. And I appreciate the work of this committee. I think we had an excellent discussion. So I appreciate that, but especially your leadership, Madam Chair. Do you anticipate working any other bills tomorrow in addition to this speedy trial bill?
Yes, thank you for your comment, Senator. And we will probably be looking to work, if we have time, probably Senate Bill 102, Senate Bill 104, and Senate Bill 105, possibly Senate Bill 150.
Thank you, Madam Chair.
Thank you. Yes, I want to commend the committee for our decorum and how we worked professionally together, and we came together on the issues before us. So good work, committee, and thank you for those who joined online as well. With that, committee, then, we are adjourned.